Very excited to see all the startup founders and entrepreneurs. And first of all, I must thank CUHK and CUHK for the kind invitation. This is my first time, although in CUHK doing or conducting sort of sharing, but I've been doing this kind of legal sharing in Science Park, Cyberport, USD, PolyU, invariably. Okay, so this time I'm very pleased to share with you, but just do a quick survey. How many of you have already attended or listened into this kind of legal sharing or talk? Anybody? Okay, that's okay. Okay, that's good. So let's dive in. So I'm not going to say too much about myself, apart from I'm both a Hong Kong qualified lawyer as well as a Greater Bay lawyer as well. So I also practice Chinese law. Okay. So first of all, I came here. I want to ask about you guys. What expectation do you have when you sign up for this legal sharing session? Any expectation, any question, anything? Oh, maybe there's something I can gather or obtain throughout this sharing. You don't need to tell me now, but you can tell me at the end of the session, okay? But one thing that I want to remind is that a lot of great minds that preparation is important. So you being a startup founder, being an entrepreneur, not only you need to be prepared with your innovation, with your technology, but also about the legal structure, the legal affairs, how to manage a company, how to deal with your investors, how to deal with your customers, how to deal with your suppliers, and also internally, your shareholders, your employees. All these would be relevant, and at the end of the day, that would create some legal relationship, that would create some legal affairs or legal matters. That is something you need to be aware. So today I have quite a bit of information. I want to avoid being in the way for your lunch hour. So I try to be swift in delivery, but I will highlight what I believe would be very important to you guys. And again, I don't intend this sharing to make you a legally expert. I only intend that you became more aware of the legal issues when you walk out of this room. Okay? So part one, for you to build and develop your venture, these are some major considerations or factors you need to think about first. What structure or what kind of legal organization that I would use to perform or to deliver the business or the technology? So this is the first question. The second one is the balance or fair relationship with your counterparts. Counterparts meaning your partners, vendors, customers, investors, employees, advisors, etc., etc. Okay? What do you mean by balance? This is in the context of rights and obligations. Your rights and obligations and your counterparts' rights and obligations. This is important. Of course, in some contract, it would be lopsided because one party has all the major sort of bargaining power, then he or she would be negotiating all the favorable terms. But in a lot of circumstances, you would be permitted to negotiate a balanced contract, a balanced sort of relationship. And this is also important because you need to manage your risks as well as your liabilities. Okay? So you don't want to enter into a contract getting like $10,000 in return and then you're risking $1 million, okay, in liability. So this is not healthy and this is not recommended. protection of assets. Obviously, for startup, you don't have a lot of assets, okay? IP, intellectual property, is one of the key assets that startups mostly own, okay? And another asset is people. People resource, human resource, is also another important asset. This is something you need to protect, okay? If you don't protect it, nobody would help you to protect it, okay? It's like your baby. If you don't protect your baby, do you expect a third party to protect the baby? No. Okay, and think about, I always talk to the founders and entrepreneurs that at the moment, a lot of you are in a very protected environment. The school, the university, the professor, the lecturer, they are very protective about your rights and your interests. But once you go out to the commercial world, that's a very different game, okay? I don't want to scare you, but very often you will be swim around by the sharks, okay? So somebody will say, oh, lawyers are sharks. Yes, you may be right, but then it depends on whether the lawyer is helping you or on the other side of the table. Thirdly, management of risk and liabilities. This again, I will repeatedly remind you about that, because when you make a decision, when you conduct certain transaction, whether it's commercial or operational, that would have the effect on the company as well as on you. So this is something you need to understand very clearly, how you can, well, the best scenario would be to avert the risk, okay? If you cannot avert totally, at least you need to mitigate or reduce the risk, okay? Let's go into the different sort of legal or business structure that you can deploy in managing your business. The first is sole proprietor. Second, partnership, and third, limited liability company. I'll go through that, but very quickly, sole proprietor meaning you yourself conducting the business in your own name. So basically, you are earning everything that the business generated. At the same time, you are also assuming all the liabilities that accrue or incur as a result. Okay? Partnership. Need two or more people, same for sole proprietorship, that you would be conducting a business together with a view to generate profit together. Okay? And again, the two partners, let's say two partners, they will earn everything together and share, and at the same time, they would bear the liabilities together, okay, and share the liabilities. So for the sole proprietorship and partnership, you are using yourself as a carrier or as an entity to conduct business. So at the end of the day, you or your partner together will be facing all the risks and liabilities. Whereas the third one, limited liability company, is a private company. Basically, it has its own independent and separate legal identity. Meaning what? Meaning that it will assume rights on its own, also the liability on its own. So let's go into sole proprietorship. Simple to set up, operate and terminate. Okay? No separate legal entity. You yourself is the one to assume liability and also enjoy the profit. Low maintenance cost. Basically, there is not a lot of like administrative sort of formalities to comply with. If you want to run a business, as long as it is a legal purpose, well, basically you just apply for business registration certificate from the Inland Revenue, then you can start your business. Very simple, okay? And at the end of the day, you earn your money you pay your sort of expense and also pay your supplier. That's it, and the remaining will be in your own pocket. Obviously, you need to pay tax, but that would be personal tax, okay? Personal ownership of assets and loans once in one's own name. Oh, the last one, I want to highlight unlimited liability. What does it mean? Any suggestion? Unlimited liability meaning that if you incur a liability that you cannot pay or your business cannot pay, it would go after your personal pocket. Okay? So it doesn't mean, oh, let's say I start up with a $100,000 business, and at the end of the day I only have 100,000. But if the liability is 200,000, then the creditor will go after you personally until you go bankrupt. So this is the unlimited liability that you need to be aware. Okay? So don't think that, oh, I just run a business. If I'm not doing well, I can close it down and walk away. No, you cannot, because this is a personal liability on you or on your partner. Partnership is the same. I want to make a sort of comparison here. Limited liability company I talked about, it has its own legal identity, meaning it assumes its own responsibility and liabilities, as well as enjoying whatever profits generated. So it is a separate legal entity from the owner. Okay. Some restrictions about what constitutes a limited liability company usually restricts the transfer of shares. Okay, so the company has its own shares. Okay, it's capital. It would be limited within its shareholders. It cannot openly invite third party to participate. Of course, you can say, oh, I want to include 1 or 2 shareholders. Yes, that's fine, but you cannot openly, like a listed company, like us trading at the stock exchange. You cannot, okay, because it's limited. Only limited to 50 members, 50 shareholders. Anything above 50 shareholders, you need to get approval from the SFC. So that would, cross the threshold, and then you would become sort of a public company in that sense. So the shareholders number is limited. Costs and complex incorporation and maintenance, meaning what? I mentioned about when you conduct a business in your own name, there's not much administrative costs to be incurred. But for this one, you need to do that because you have to be compliant with the company's registry's requirement. So there would be certain incorporation procedure you need to follow, and then every year you have certain compliance matter that you need to comply with. For example, every year a company would need to do an audit. Okay, they would need to engage a CPA firm to do an audit, and then the audit will need to be submitted to the company's registry. Okay, so this is an obligation of the company. If you don't do that, you'll get a fine, or firstly a warning, and then later on a fine based on that the company is in breach of the law. Okay, so this is the costs and the procedures requirement. Highly regulated by law and statute, meaning that the conduct of business, how to manage a company internally and externally, it will be regulated by law. Companies ordinance would be the main sort of law to reference to, and there would be other laws as well. Limited liability. Now, this goes back to what we describe as proprietorship, sole proprietorship, unlimited liability. This is limited liability, meaning that if you were the owner of the company, and if the company assumed a liability, you would not be liable. you will only be liable for what you have agreed to contribute as a capital of the company. Let's say if the company has a capital of $1,000 and you agree to subscribe $500 sort of equivalent of shares. So your liability is only the $500. And if the company faces a claim from its supplier or creditor of $1 million, it has nothing to do with you. Your liability is capped at the $500. Okay? So this is the beauty of having a limited liability company, because the liability is limited to what you have agreed to subscribe for the share capital of the company. The last point I want to mention that I will also explain in further slides is about the division of ownership and management. So think about when you run a business in your own name. You are both the manager as well as the owner, right? But for limited liability company, no. The ownership and the management, they are separated. Ownership is shareholders. Management, directors, or the officer or managers appointed by the board of directors. Okay, that would be the sort of decision-making body. But don't mix up. Doesn't mean that you are a shareholder, you would be automatically a director of the company. No. Okay? So the two, they are very separate. Of course, under the law, under the company's ordinance, the shareholders would have a right to appoint director, but it doesn't mean that the shareholder will be the same as director. So this is very important, because a lot of people can easily mix up that, oh, I own the shares of the company, so I run the company. No, technically you don't run the company. Technically it's the board running the company. Okay, if you are not a board member, the decision making of the day-to-day business or the operation of the company would not come to you. Shareholders will have some limited rights, okay, but the rights would not go straight to the management of the company. So this is very important. Partnership, very quickly, I mentioned about, same as sole proprietorship. If you join together, form a partnership, then you run the business in the partnership's name, share profit, share the liabilities. Okay, the general partnership would have all the relevant governance terms about how this partnership should be managed. And then the limited partnership is a bit different, because this is, you sometimes may have heard about LP, GP sort of arrangement. This is very often being used by VC, by funds, because the GP basically, they are the one managing the venture. They do everything, they make all the decisions, okay? But limited partner, they passively just enjoy the financial benefits, okay, and liabilities. But at the end of the day, if anything went wrong, the GP would have unlimited liability, because they are the one calling all the shots, they are the one making all the decisions. So limited partner would only be liable for whatever they have agreed to contribute in the partnership. So this is limited to that sort of scope. And lastly, limited partnership funds is not so much related to you, it's more related to law firm setup, okay? Very quickly about summarizing what I've just described. So when you consider using a vehicle, a structure to deploy your business, think about all these factors that would be relevant. Cost, how much you spend in forming the organization or the vehicle, and scale of business. Are you at the early stage or mature stage? So when you're at the mature stage, obviously it's more sort of conveniently and suitable to use a company to house all the activities. liability, okay, this is limited liability, unlimited liability sort of consideration, transferability and continuation. This is more to do with a company. If you have company shares, you want to transfer or you want to continue with the company's operation. So this is another factor you need to consider. Others, like for example, tax. Okay, tax is also a consideration. So for sole proprietorship, you only pay for personal tax, whereas for company, you pay for company tax. So the regime is very different. And this is something you need to think about. Now we come to the stakeholders. I have highlight three main categories of stakeholders in a company that you should be aware of. I talk about shareholders. So this is some basic idea about shareholders. Shareholders is the owner, as I said, okay? But remember, although it is owner, it does not, or he or she does not own directly the assets of the company. Who owns the assets of the company? Anyone? Sorry?
The company itself.
Yes, exactly. The company owns the assets. You, as a shareholder, you don't directly own the assets. When you can sort of materialize, or when you want to retrieve the assets, it's only in the circumstances that when the company got liquidated or dissolved. Okay? So if the company go busted, then maybe if something left, then you can enjoy, sharing those, leftover of assets. Okay, after paying off all the creditors. So remember, you don't own the assets. The assets is owned by the company because the company has an independent and separate legal identity. So what does a shareholder enjoy? It enjoys a right to dividend and the interest in the assets proportionate to their shareholding only when the company is dissolved or liquidated. Okay? Their liability, as I mentioned, is limited to whatever share capital they agree to subscribe. Okay? So if they agree to subscribe for $100, that will be their liability. That's the max. Normally, it will not go after that. The exception is when there is fraud or fraudulent dealing. Then, what we call, in legal term, piercing the corporate veil, then the creditors can go after the shareholders. But if there is no fraud or no fraudulent dealing involved, then your liability is only limited to the share capital you subscribe for. Need to differentiate the capacity of an owner from that of a manager. That is something I already mentioned. Obligations: contribute the share capital, assume liabilities of the company, limited to their capital contribution. Okay, the same sort of meaning. Normally, the next two will be very often reflected in the shareholders' agreement because the owner, the shareholder, they may be in the same industry with the company. So think about, the shareholder may have a side business, competing with the venture you're operating. So very often in the shareholders agreement, we put in non-compete and non-solicitation provisions, restricting that the shareholder cannot compete in the same business that the company is operating. Non-compete. So basically, you cannot engage in any kind of same business or helping other people conducting the same business against the company. Non-solicitation meaning that you cannot approach client, customers, or employees, okay, try to steal them away and move it to your side business. You can't do that. So this is some kind of restrictions. Normally, restricting the founders, because especially when they invest the company into the company, they want to make sure that the founders, you don't have any side business doing the same thing. And it's like invest money into your company, and then you may be conducting competing business, that would be problematic, okay? Other obligation prescribed in the constitution, document, and legislations. Okay, very quickly, rights of shareholders. Normally reflecting in the shareholders meeting, voting, changing company name, altering or amending the company's articles of association. Anybody, what is articles of association? Have you come across that? Anyone has a company now or not? You will come across that when you set up a company. That is the constitutional document of the company. So basically, there are rules of internal governance, how the company should operate, how the directors should operate holding a meeting, how the shareholder should hold a meeting, how the dividend is to be distributed, okay? How the shares are being transferred or under what restrictions, etc., etc., etc. That would be the constitutional documents of a company. Removing directors, auditors, voluntary winding up, receiving profits and dividends. Okay, that's some examples. Right, here I want to talk a bit about shareholders meeting. What rights would you have? Normally at the shareholders meeting, the shareholders would be determining some major matters, not the operational matters, okay? The operational matters would be left for the directors to do. This is more for major affairs like disposing company's assets, borrowing a large amount of loan, issuing new securities, new shares, okay? Removing or appointing directors, etc., etc. So that's very important to the owner. So that's why you need to be determined at the shareholders meeting, and that requires special resolution. Okay, that would be under law require at least holding share capital of not less than 75%. But if you have an investor coming in, they may require a higher percentage, okay? Because they want to make sure that they would be involved. So normally, 75% will be changed to unanimous approval, 100%, okay, or 90%. Because the investor, being minority shareholder, the percentage-wise they are small, holding small percentage. They want to make sure that some of these key items would be in their hands to veto at least, okay? To block it if they don't agree. If they do not reserve these rights, the majority shareholder can decide whatever they want to do. So this is what we call the reserve matters that normally an investor would require to build into the shareholders agreement. Ordinary resolution. The threshold of passing a resolution would be lower. This is about 50%. More than 50% you can pass ordinary resolution. That would be for a lot of general matters. Similarly, for directors, if the board hold a directors meeting, normally when they decide on items or matters, they would use ordinary resolution to pass and resolve the decision. Okay, so this is very common, more than 50%. So when you think about the setup of your board, okay, because I'm dealing with some cases now that the founders, you know, they will allow investor to appoint one more director, and then adding more directors in the company. But then I have to remind them that you need to make sure that you have the control of the board. Otherwise, who would decide the decision of the company? The investors. You don't want that to happen, right? As founders, as entrepreneurs, maybe at the later stage, your control would be less, but at the early stage, you should try to maintain the control because you want to steer the direction of the company. You want to decide how the company is to be innovated, how your technology to be evolve, how the company is to be operated. So make sure that when you think about the board composition, you would still retain control, okay? The other rights is basically the shareholders holding 5% can request the directors to call for a shareholders meeting, 10% can apply to court to cancel any decision on variations of rights of the shares. Holder of 35%, as I mentioned, can block a special resolution. Okay, directors. Managers, as I mentioned, they are not owners, they are managers. They're managers of the company. They manage everything of the company. So make sure that you have the right person at the board level and you have the control. Every private company must at least have one director. Okay, this is the statutory requirement. Must be of age of 18, must not be having a bankrupt sort of status, etc., etc. Powers and responsibility, as I mentioned, day-to-day management, that would be their responsibility. Duties, okay, this is also important. If you were being appointed a director, don't think about, oh, great, I'm a director, but think about the responsibility. Under the Hong Kong law, being a director has certain sort of minimum statutory or legal responsibilities. You have to observe it, otherwise you will attract legal liabilities. Legal liabilities can be both civil liability and criminal liability. So this is something, you need to think carefully. You have what we call the duty of care. Normally the duty of care is an English law concept. Basically, the director needs to perform his or her duty with reasonable care. Expected as any reasonable person in the same position would be doing the same, that kind of standard. If you go below that standard, then you could be liable. You could be liable to the company and you could be liable to the shareholders. Okay? There's a court case, Justice Mimi Chan said, a duty of care in utmost good faith. They must exercise their powers for the benefit and in the best interests of the company as a whole. What does it mean by the best interests of the company as a whole? The company as a whole. Any suggestion? What is the company as a whole? The company as a whole means that you cannot just represent or act in the best interest of one shareholder. Let's say you have a majority shareholder. Maybe the majority shareholder appoint you as a director. So you make a decision, and at the end of the day, the ultimate benefit would benefit the majority shareholder, but not the company. Then you are in breach. So your decision, whatever you make, it would need to benefit the whole company, all the shareholders, okay? In other words, all the shareholders you need to consider, not just one or two shareholders. So this is something very important. And the third category, employees. So this is very important for you guys because, as I mentioned, human capital is very important in addition to IP. So employees, you need to make sure that you're compliant with the labor law. There are various labor law governing, and there are certain schemes that you need to be adhesive to. So don't think about that employee is like an independent contractor. They have different legal capacity. Someone acting as a contractor, they enjoy different benefits and rights. They do not have the protection of the labor law in Hong Kong because labor law is very onerous in protecting the employee. Okay, the employee enjoys a lot of protection, whereas contractor doesn't, because the contractor is merely a contractual position. whatever stated in the contract, then they can rely on the contractual provision. Anything beyond that, maybe not, okay? And one example is about payment. I asked this question about, if you are late to pay your employee, like 2 weeks, by 2 weeks, you tell your employee, oh, we have a cash flow issue, so just bear with us and we pay 2 weeks later. Do you think it's okay? A lot of people don't know about that. It's not okay, because under the employment law, if you are late by 7 days in making payment of the salary when due, 7 days, you are already in breach of the employment ordinance. Okay, don't think about, oh, just 2 weeks, what's the big deal? No, it's a big deal, okay? And at the end of the day, if the company is in breach, the person in charge of making the decision will also be liable. So this is something you need to bear in mind. Okay, so we touched on a lot of things so far. Any question before I move on? Okay. Yes?
A naive question. I probably explained it just now, but from an employee's point of view, so who's the boss? Is the management boss or shareholder the real boss?
The company.
The company is the boss.
Yes. The company is the boss who is making decision. The directors, the GM, the manager, but they are representing the company. So at the end of the day, you sue or you complain to the labor tribunal for any breach, any problem, it's the company, not an individual's name, not the shareholder, not the manager, not the GM, not the director. It's the company. Because remember, who is signing your employment contract? It's the company. It's not an individual person. Unless that person is running his own business in his own name. Otherwise, if the company is signing up your contract, then the company will assume all the liability. Okay. The next part is important. I just give a few examples just to highlight that you may come across when your company grow and expand, because a lot of these legal documents, very often you will come across. And just give you a taste of what they are and what sort of matters you need to be alert. Okay, a few examples. Articles of association, we talk about founders agreement, shareholders agreement, employment contract, confidentiality agreement or non-disclosure agreement, employee invention assignment agreement. Okay, let's go to this one we talked about. Founders agreement, storytelling. I have a story to tell. Actually, it's a real case. A few years ago, I assisted 2 founders of a startup company. Actually, in that startup company, there are 4 founders in total. And they did pretty well, and they attracted a serious investor. But the problem is, there isn't any founders agreement between these 4 founders. Okay? And the 2 gentlemen came to me. One is in charge of operation, the other is in charge of marketing and sales. Okay? They are very nice gentlemen, young entrepreneurs. But then the problem is, the company finance and all the dealing with the investors were done by the other 2 founders. And these 2 founders had no clue about what had been negotiated. And then later they found out that, they got screwed in the sense that a lot of benefits going to that 2 founders, they did not enjoy. Why? First of all, they don't have a founders agreement. They don't sort of have a foundation to state who is doing what and what rights and obligations were being allocated among the founders. Okay, so one example, one of the items that the 2 other founders enjoy would be that the serious investor would be willing to buy out some of their old shares. Whereas the other two founders, their old shares, they cannot do anything about it. They got stuck. And another thing is, these two young gentlemen, they are not even at the board level. They are not directors. The other two founders, they are the directors of the board. They make all the decisions. Okay? So my client, the two young men, they are only having an employment contract and they have some shares. That's all. So at the end of the day, they don't control the company. The management is nothing to do with that. Strictly speaking, if the company wants to fire them, the company just gives them the necessary notice period, and that's it. They will be kicked out from the company. It sounds very bad, isn't it? So that's why it's very important to think about that, when you enter into a venture, even though you are good friends, good classmates, but I think it's better to state the fundamental, what rights and obligations you have between your partners, okay? At the end of the day, there will be no quarrels. So obviously, my two clients at the end, they got some compensation, but it's not as good as, if they were, directors of the company, they have more control and more say and more bargaining, okay? So founders agreement. Actually, this is at the early stage when you create your entity with your partners. That would be the document that you normally would have. Okay, but I know some startups say, oh, I don't want to incur costs. I don't want to spend money. Blah blah blah. They orally agree something. Okay, but at the end of the day, when the company grows and things change, and whether the oral agreement will be remembered or the details will be recalled. So oral agreement obviously is enforceable under law, but the problem is if you don't have the details to support that, it's very difficult to enforce it. So the main provisions for the founders agreement will be ownership of venture or business concept. So someone developed something, IP, some technology, who owns it? How does it being sort of allocated, in this company? But normally, the founders agreement here would be at the early stage when no company is formed. Okay, it's purely a POC, purely, you have an idea how to work together to develop something together. Transfer of business concept to the company. So if partner A has a concept, then you want this concept to be transferred to the company at the end, not still remain with partner A, because remaining with partner A could mean that this is his or her property. You don't want that. So have to specify that the business concept or the IP, how would that be transferred to the company at the end? Ownership management structure of the company. So you have to think about with your partner, co-founders, who is doing what, someone doing the finance, someone doing the marketing and sales, etc., etc. Contribution founders. Again, that's important because when you think about when you have early startup, not all of you would have money to contribute, okay? But maybe your IP, maybe your time, maybe your experience, maybe your network, all of this can be computed and quantified as a dollar sign. As long as you guys agree, oh, I spend like 3 days a week, every week, working on this project, that can be quantified to a certain dollar sign, equivalent to certain value, and then use it to, to calculate what kind of percentage of the ownership that you would have in this venture. Founders' rights and obligations. So again, this is important because you need to be fair, okay? And then this is something you, as early as you can establish, then you can have an agreed sort of foundation. sale and transfer founders' interest. This is something relevant because I come across some startup that after 1 or 2 years, one of the founders say, "Oh, I don't want to do this. I want to walk out. Okay, I want to get my money back, or I want to get whatever." If you don't have an agreement, then it's very problematic because you don't have a mechanism how to calculate, how to make an exit arrangement for this founder. Like the existing partner, the remaining partner would buy out his or her shares or what, you know? Or can he or she introduce a new, a third-party person, third-party to assume his shares in the company? Okay? Obviously, we don't want that. We don't know that person, right? So this is something you need to think about. Exit arrangements, again. So if someone wants to leave, that is something you need to think about. Shareholders agreement, that's the advanced level of the founders agreement, because normally a shareholders agreement would be considered when you have third-party investors, okay? Like if you are doing angel financing or even series financing, very often you will enter into a shareholders agreement. There are a lot of provisions. Let me think. Okay, so they would be talking about the management. Okay, again, I have repeatedly mentioned about the management business operation. Okay, so how the board is to be composed and who is having certain rights or not. Because when you think about the shareholder structure, when you think about the board composition, this is meaning that will affect the ongoing conduct of your company. So you want to make sure that you as the founders would have the major control. Okay, you don't want the investor coming in and dictating, "Oh, you need to do this and that." And this is something I very often come across. The company, they don't want to give too much right to the investors because they don't want the innovation, the technology development would be dictated by the investor. The investor could have some good idea, but this for reference, not, directing the way that the company is going, because the company is relying on its founders. The investor interested in the founders because they believe the founders could do well. So you as founders also need to make sure this is happening along your way, not along the way of a third party. Reserve matters, we talked about restrictions, limitation on share transfer. This is something you will come across, especially that it's all related to the investors, because they want to make sure that any share transfer in the company will be restricted to certain provisions. Especially the founders' shares cannot be freely transferable. They don't want the founders to leave the company. Okay, they invested money into the company, and then the founder, out of the blue, say, "Oh, I want to walk out. I want to sell my shares. I don't want to do anything." Then the investors got stuck. So they want to make sure that the founder's shares cannot be easily transferable. There would be a lot of restrictions on that, okay? Restrictive covenants, non-compete, non-solicitation, I've earlier mentioned about it. So they want to make sure the founders, they don't compete with the company's business, okay? So, and also solicit their customers or employees. Liquidation preference is more for the investors, because they will negotiate that they will have priority if one day the company got into liquidation, winding up, and assets remaining, they want to have the first share of whatever remain, okay? So as to compensate their investment. So this is something when you deal with the investor, you will need to negotiate with them and to find a fair sort of arrangement. Another story. Confidentiality agreement, non-disclosure agreement, NDA. Okay. You guys have signed the NDA before? Any confidentiality agreement before? Okay.
A lot of them.
Okay.
Yeah, a lot of people are interested in
This is, I have to highlight that this is very important. Before you do anything, you need to have a confidentiality agreement or NDA signed. Okay, the story is this. A startup founder met a big name household company's business manager. Okay? And the business manager said, oh, Mr. Founder, your technology is very interesting. Our business team may have some collaboration or even investment into your company. And the founder said, great. And the business manager asked, can I have some materials for us to study? Please provide some materials about your technology, your product. The founder said, great, I'll send it to you. Okay? No NDA, no confidentiality agreement signed. Okay? And then a few days later, the business manager came back and said, oh, your product, your technology is very much sort of aligned with our company's business direction. Maybe we can seriously consider doing a partnership or investment with you. But you know, your information is a bit not detailed enough. We will need to get our senior management and operation team to study. And one thing the business manager assured the founder, don't worry, you send it to us. We'll keep it confidential. You know, we are a big company, so we are complying with the law. So you have to trust us. The founder said, okay. Then send another lot of technology or product information to this business manager. And after a week, this business manager came back and said, oh, we studied your technology and your product. But unfortunately, at the moment, there is still a gap there. We cannot cross, and it will take some time for us to, you know, develop and in order to have a serious collaboration with you. So why don't we wait for, you know, a couple of months? Okay, you know what? A couple of months later, what happened? This big name household company, they set up a new business team doing the exact product development that this founder is doing. And what can the founders do? Nothing. Why? Because there's no confidentiality agreement signed when he shared the information with the business manager. It's sad, isn't it? It's very bad. I'm not saying that the confidentiality agreement, you know, is a bulletproof sort of thing. But if a company signs it, at least it has to caution. At least I would say their lawyer would remind them that, hey, don't do anything silly. Okay? They would not boldly or openly, you know, use your confidential information. But without one, you are in God's help. Anyway, confidentiality information, so it captures a wide scope of what constitutes confidential information, ranging from technical information, technical know-how, tangible, intangible materials, plans, technology, trade secrets, customer information, etc., including commercial and financial information. Okay, so very wide range of confidential information being covered. Major provision is you cannot share my confidential information without my consent. Okay, so this is very important. Exception would be when such information is in the public domain or being authorized by a court or government body, then you know it can be shared. Otherwise, you cannot. Employee invention assignment agreement. This is very relevant to those of you who do R&D. Okay? Because normally when someone develops his or her technology IP, the natural thinking is that that IP would belong to that person. Okay? This is the natural sort of scenario. But because the employee is hired to develop the IP for the company, so basically it is not developed in his or her own name, it's developed in the name of the company. To avoid any sort of a dispute, normally when you hire a new employee, you will also, in addition to signing an employment agreement, you will also ask the person to sign this invention assignment agreement, so that he would undertake that whatever during the employment time he or she developed the IP, that IP would go to the company. Okay, if this IP will need to be transferred by certain formalities, doing registration, then this person, this employee will need to help to complete all those formalities. So this is what it's about. Okay. I want to be quick, so that I want to let you try the quiz. I got some quiz. Hopefully you can answer them all if you have listened into what I said. Okay. Angel and Ben each contributed 100,000 to a venture, to form a venture together, specializing in AI-related development. No company is formed. What is the nature and scope of liability of Angel and Ben? Who goes for A? Who goes for 1? Limited and personally liable. Anyone? Who goes for 2? Unlimited and personally liable. A lot of hands. 3, partially limited and personally liable. 4, limited and not personally liable. Great, you guys done well. 2 is the right answer. Q2. So a limited liability company is formed. The company enters into a service agreement with the customer and found later on that the company is in breach. So the customer sue A and B Limited for loss of damage of $500,000. What is the liability of A and B Limited? Answer 1, $500,000. Okay. We've got 2 shows of hands. 2, 200,000. 3, none of the above. 500,000, $500,000 would be the liability of the company. Remember, the service company is suing the company for $500,000. So the company's liability is $500,000. Okay, of course, it can defend and dispute later on, but on the face of it, the liability is $500,000. Okay, so the next question is, what is the liability of Angel and Ben respectively? Answer 1, $500,000. Who goes for $500,000? No. 2, 200,000. Okay. 3, 100,000. Okay. I saw 2 hands. Okay. 4, none of the above. Okay. The answer is 3, 100,000. Why? Remember, when they first started the company, each contributed 100,000. And limited liability company, the shareholders would be liable for their capital contribution, i.e. the 100,000. Great. The 100,000 answer, it is. 3, an agreement to be enforceable can be either made verbally or in writing. True or false? Who goes for true? Okay. False? Okay. Actually, it's true. I earlier mentioned about oral agreement is enforceable, but the difficulty is the details, because you cannot have too much detail to support who is saying what. Okay, although the oral agreement, legally speaking, is enforceable, but if you don't have enough detail to support, it's very difficult for enforcement. Q4, NDA is the same as MOU. True or false? 1, true? False? Yes. I didn't talk about MOU. It's a trick, okay? MOU basically is an early agreement like a term sheet, okay? When you enter into some negotiation, let's say if you are doing fundraising, with the investors, then you enter into MOU documenting some major terms, okay, before you create a definitive agreement. Okay, lastly, Q5, a Hong Kong incorporated company must have at least one director and 2 shareholders. Who says true? Anyone? False? Yes, false. Actually, under the company's ordinance, the minimum requirement for a company to have is 1 director and 1 shareholder. Okay, this is the minimum requirement. Q6, a shareholder directly owns the assets of the company. True or false? Who goes for true? No? False. Oh, very good. So you have listened well. Okay, so take away. Okay, just a few bullet points. Consider appropriate legal structure to establish a business. Okay, beware of the risks and liabilities. Okay, as I said, I don't expect you to be a legal expert, but at least you have the awareness. You know, okay, something, not smelling, not right, okay, so we need to be careful. Be vigilant of the rights and obligations relating to the stakeholders of the company, directors, shareholders, employees, etc. Okay? Consider with prudence the use of legal documents. Well, that's something I want to highlight, because I talked to some founders and say, engaging a lawyer is too expensive. Why don't I just go to Google or go to DeepSeek to download a legal document? Well, you can if nothing happens. But the problem is the DeepSeek would hallucinate. Okay? I tried that. They will create a case with reference exactly, it looks like a real reference, but there is no case in existence. Okay, you will tell, this is the case, and it has the summary, but sorry, this case has never existed in this world. Okay, so again, okay, remember, legal liability can be big. Okay, don't just think about saving some costs, because if you don't have a professional and expert to help you, if everything goes well in the blue sky scenario, of course, nothing happened. But if something went wrong, then you got stuck. Lastly, look out for traps and pitfalls in the legal documents, in the legal agreements. So what you need to be aware, what sort of responsibility, liabilities that I will assume. So this is very important. If in doubt, look to your legal advisor. Okay, that's the end of my PPT. And